I have based this script on the MCA Registrar of Companies Karnataka Adjudication Order dated July 17, 2026 concerning SDU Projects Private Limited. The imagine this A company gives a loan of 50 lakh rupees. The money is genuinely advanced. The transaction appears in the financial statements. There is no allegation that the money disappeared. But there is one problem. The board never passed the required resolution, and years later, the registrar comes back with a penalty order. In this masterclass, I will show you exactly how that happened, which provision was violated, how the MCA calculated the penalty, what the company argued, why that defense failed, and the compliance lesson every company secretary and director should remember. Stay with me because the most important part comes at the end. The question is not only whether the company had the power to borrow or lend. The real question is, did the board exercise that power in the legally prescribed manner? Welcome to Corporate and Securities Law Compass, navigating the law with clarity. Today we are going inside a real MCA adjudication order. This is not just a theoretical discussion of Section 179. This is a practical compliance story. The order was passed by the Registrar of Companies Karnataka on 17th July 2026 against SDU Projects Private Limited under Section 454 of the Companies Act 2013, read with Rule 3 of the Companies Adjudication of Penalties Rules 2014. The allegation was violation of Section 179, subsection 3, clause D. And the subject was something every finance team and company secretary deals with: borrowing and lending decisions of a company. The order records that the company had advanced a loan of 50 lakh rupees and had also borrowed additional amounts from related parties without passing the required board resolutions. The final penalty imposed was 90,000 rupees. But the real lesson is much bigger than 90,000 rupees. It is about how a transaction becomes a corporate compliance issue because the required decision-making process was not followed. What you will learn. In this masterclass, we will understand Section 179, subsection 3, clause D, what the board has to do when the company borrows money, and how board powers operate through resolutions. The difference between a transaction happening and the board legally exercising its power. The facts of the SDU projects case. The inspection under Section 206. The explanation given by the company. Why the registrar did not accept that explanation. Section 450 and the penalty mechanism. Section 454 and adjudication. Rule 3 of the Company's Adjudication of Penalties, Rules 2014. The penalty calculation. The small company exception under Section 446B. The practical compliance lesson. And finally, I will give you a question. You tell me the answer in the comments. Section 1. The core provision. Let us start with Section 179. Section 179 deals with the powers of the Board of Directors. The order specifically refers to Section 179, subsection 3, clause D. The provision states that the board shall exercise the power to borrow monies on behalf of the company by means of resolutions passed at meetings of the board. Now stop here. This sentence contains the entire compliance principle. Borrowing is not merely a finance department decision. It is a board-level matter. The company must exercise this power through the prescribed board process. So there are two separate questions. First, did the company borrow money? Second, did the board exercise the borrowing power through the required resolution? A company can answer yes to the first question and still have a compliance problem with the second. That is exactly where this case becomes interesting. Section 2. The real story. Now let us enter the facts. During an inspection under Section 206, subsection 5, the inspector examined the company's records. The financial statements for the year ended 31st March 2017 showed that the company had provided a loan of 50 lakh rupees to SDU Beverages Private Limited during that year. But according to the inspection findings, the company had failed to pass the required board resolution for advancing that loan. The order therefore treated this as a violation of Section 179, subsection 3. And then came the second part. The MGT 9 and financial statements for the financial years 2016-17, 2017-18, and 2018-19 showed additional borrowings from related parties. The amounts mentioned were 9,693 rupees, 58,000 rupees, and 2,59,100 rupees respectively. Again, the issue was not simply whether money was borrowed. The issue was that the company had failed to pass the required board resolution prior to borrowing those amounts. That distinction is critical. As Section 3. Why does prior board approval matter? Now imagine a simple example. Suppose the finance department tells the bank, we need 10 lakh rupees. The bank transfers the money. The company records the borrowing in its books. The accounts are correct. But nobody checks whether the board has passed the resolution required under Section 179, subsection 3, clause D. The transaction has happened, but the corporate decision-making process has not been completed in the prescribed manner. That is the compliance gap. So the company secretary should not treat the board resolution as a paperwork exercise. The resolution is evidence that the competent corporate authority actually exercised the statutory power. Section 4. The company's defense. Now comes the interesting part. The company did not simply accept the allegation. It gave an explanation. The order records that the company argued that certain payments were reimbursements of statutory and other payments incurred on behalf of the company. The company stated that these were classified as short-term loans and were repayable on demand. The argument was essentially, these were not actual loans. Therefore, a board resolution was not warranted. At first glance, that may sound reasonable. But the registrar did not accept it. The order records that the reply was found not tenable. The inspector had identified the violation and the competent authority had accepted the inspection finding and directed the ROC to initiate penal action. Section 5. Important exception or not. Now here is a very important compliance lesson. Calling an amount a reimbursement does not automatically decide its legal character. The substance of the transaction matters. If an amount is reflected and treated in the company's records as a borrowing or loan arrangement, the company needs to carefully examine whether the relevant statutory board approval requirements are triggered. This is why classification in the books and corporate approvals should be aligned. Finance records, board minutes, loan agreements, bank transactions, related party records, and statutory disclosures. All of these should tell the same story. Section 6. Section 450. Now we reach the penalty provision. Section 450 is the general penalty provision where a company or officer contravenes a provision of the Companies Act or rules, and no specific penalty or punishment is provided elsewhere. The order states that the penalty is 10,000 rupees, and in case of continuing contravention, an additional 1,000 rupees for every day after the first day, subject to the statutory maximum stated in the order. For a company, The maximum stated is 2 lakh rupees. For an officer in default or other person, the maximum stated is 50,000 rupees. This is where the compliance risk becomes serious. A seemingly small procedural failure can potentially continue and increase the exposure. Section 7. Section 454. Now, who actually imposes this penalty? This is where Section 454 comes into the story. The order itself is titled as an Order of Adjudication of Penalty under Section 454. The Ministry of Corporate Affairs had appointed the officer as an adjudicating officer. The adjudication process, therefore, becomes the mechanism through which the alleged contravention is examined and penalty is determined. And this is not an instant penalty. The order records that the company and directors were given a reasonable opportunity. A preliminary findings letter was issued. The company replied. Later, an adjudication hearing notice was issued. A physical hearing was held. The company's practicing company secretary appeared and made submissions. Only after considering the facts and submissions did the adjudicating authority pass the penalty order. Section 8. Rule 3. Now let us bring in the rules. The order specifically states that the adjudication was undertaken under Section 454, read with Rule 3 of the Company's Adjudication of Penalties, Rules 2014. So remember the compliance chain. Companies Act Section 179. Then the alleged violation, Section 450. Then the penalty framework, Section 454. Then the adjudication mechanism. And Rule 3 of the Adjudication of Penalties rules. This is how the provisions connect. Section 9. Small company exception. Now comes another important point. Could the company receive the benefit of the lesser penalty applicable to a small company? The answer in this case was no. The order specifically records that the company did not fall within the definition of a small company under Section 2, subsection 85. Therefore, the lesser penalty provision under Section 446B was held to be not applicable. This is an important compliance checkpoint. Whenever a penalty is being considered, do not stop at the charging provision. Always check whether any statutory relaxation or lesser penalty provision applies. Here, the company could not use Section 446B because it did not qualify as a small company. Section 10. The final penalty. Now let us look at the numbers. For the company, 10,000 rupees for 2016-17, 10,000 rupees for 2017-18, 10,000 rupees for 2018-19, total 30,000 rupees. For the managing director, 10,000 rupees for each of the 3 years, total 30,000 rupees. For the director, again 10,000 rupees for each of the 3 years, total 30,000 rupees. Grand total 90,000 rupees. The company and directors were directed to pay the penalty within 90 days from receipt of the order and file Form INC 28 attaching the order and payment challans. The order also states that directors were required to pay their penalty from their own funds. Section 11. The appeal window. Now another important compliance point. The order states that an appeal, if any, may be filed before the Regional Director, Southwest Region, Bengaluru, within 60 days from receipt of the order. The appeal is to be filed in Form ADJ and accompanied by a certified copy of the order. So even after an adjudication order, the legal process does not necessarily end there. There is an appeal mechanism. Section 12. What about circulars? Now you may ask, was there a circular in this case that changed the rule? Based strictly on the adjudication order provided here, the order does not identify any specific MCA circular or SEBI circular as the basis of the contravention. The order relies on the Companies Act 2013 and the Companies Adjudication of Penalties Rules 2014. Therefore, I would not insert a circular into this particular case study without separate verification. That is an important research discipline. Do not mention a circular merely because the topic sounds like it should have one. Always trace the circular to the actual source. Section 13. Amendments. The order refers to the Companies Act and the rules as amended from time to time. However, the provided order does not give a detailed amendment history of Section 179, subsection 3, clause D. Therefore, for this case study, the safest conclusion is the central compliance requirement identified by the order is the requirement for the board to exercise the borrowing power through a resolution passed at a board meeting. If you want to compare the historical wording with the present law, that should be treated as a separate amendment analysis. Section 14. Proviso and Sub-Rules. Now, an important point for students. Do not assume that every provision has multiple provisos or sub-rules that must be discussed simply because you are studying the section. In this particular adjudication order, the core factual issue is Section 179, subsection 3, clause D. The order also refers to Rule 3 of the Adjudication of Penalties rules. It does not set out a detailed proviso-based exception under Section 179, subsection 3, clause D. Therefore, the focus should remain on the statutory requirement actually applied by the adjudicating authority. Section 15. Practical Company Secretary Checklist. Now let us convert this case into practical compliance. Before a company borrows money, check whether the matter requires board approval. Identify the relevant provision. Prepare the board note. Place the matter before the board. Pass the required resolution. Record the resolution properly in the minutes. Complete the transaction. Maintain the supporting documents. Ensure the accounting treatment matches the legal documentation. Check related party implications where applicable. And preserve the complete audit trail. Because years later, an inspector may not only ask, where is the loan agreement? The inspector may ask, where is the board resolution? Section 16. The Netflix moment. Now imagine this case from the perspective of a company secretary. The transaction happened years ago. The accounts are closed. The annual reports have been filed. Everyone thinks the matter is finished. Then an inspection begins. The inspector opens the financial statements, finds the transaction, checks the board minutes, and suddenly one document becomes the center of the entire case. The board resolution. That is the real lesson. Corporate compliance is often not tested when the transaction happens. It is tested years later when someone asks, show me the authority under which the transaction was approved. Example. Let us take a fresh example. Company A wants to borrow 5 crore rupees from a bank. The CFO negotiates the terms. The bank approves the facility. The amount is disbursed. But before the borrowing happens, the required board resolution has not been passed. Question. Can the CFO simply say, the bank approved it, the accounts team recorded it, therefore everything is fine? No. The corporate approval requirement has to be examined independently. The existence of a commercial transaction does not automatically prove that the statutory corporate approval process was followed. Comment. Question. Now it is your turn. Suppose a company borrowed money from a related party. The amount was properly recorded in the financial statements, but the required board resolution under Section 179, subsection 3, clause D was not passed. Later, the company argues this was only a short-term arrangement and therefore board approval was unnecessary. Based on the SDU project's order, would you accept that defense? Yes or no? Comment your answer below and tell me the reason in one sentence. Let us recap this case in less than 1 minute. Point 1. Section 179, subsection 3, clause D requires the board to exercise the power to borrow monies through a resolution passed at a board meeting. Point 2. The SDU project's order involved a 50 lakh rupee loan advanced without the required board resolution. Point 3. Additional borrowings from related parties were also identified without the required board resolution. Point 4. The company's reimbursement argument was not accepted by the adjudicating authority. Point 5. Section 450 provided the penalty framework. Point 6. Section 454 provided the adjudication mechanism. Point 7. Rule 3 of the Adjudication of Penalties rules was applied in the adjudication process. Point 8. The company did not qualify for the lesser penalty available to a small company under Section 446B. Point 9. The total penalty imposed in the order was 90,000 rupees. And the biggest lesson is simple. Do not look only at whether the transaction was completed. Look at whether the transaction was authorized through the correct corporate process. If you are a company secretary, CS student, compliance professional, CA, lawyer, director, or anyone dealing with corporate law, these are exactly the practical issues you need to understand. Because one missing board resolution can turn an ordinary transaction into an adjudication case years later. For more practical Companies Act, SEBI, and corporate compliance masterclasses, subscribe to Corporate and Securities Law Compass, navigating the law with clarity. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. They do not represent the views of my employer, any organization with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. The content is based on publicly available laws, rules, regulations, judicial pronouncements, and regulatory materials, or on hypothetical examples prepared for educational purposes. No confidential, proprietary, or unpublished information is used or disclosed. This channel does not provide legal, tax, financial, accounting, investment, or other professional advice. Viewers should consult qualified professionals before making any legal, business, or investment decisions. While every reasonable effort has been made to ensure accuracy, laws and regulations are subject to change. Accordingly, neither I nor this channel accepts any liability for any loss or consequences arising from reliance on the information presented. All trademarks, company names, and logos belong to their respective owners and are used only for educational, commentary, and informational purposes. Copyright Corporate and Securities Law Compass, navigating law with clarity. All rights reserved.